Hi, it's Guy DiMartino. Today I'd like to talk a little bit about what happens when bank accounts do not jive with a person's estate planning documents, whether it's a will or a trust. I can't tell you how many phone calls I get over the months and years regarding this issue. This is the typical scenario that we see. We have an elderly parent, and the elderly parent thought about their estate planning, and they prepared either a trust where they made all their kids beneficiaries equally of the trust, or the same thing in the will. They prepared a will and they leave their stuff equally to their children. Hey, they love their children and they want their children to have equal distribution of everything they have. But then what happens a lot of times is, because we're a pretty mobile society, many of the children move away. And sometimes there's one child that stays back or lives in the same area and takes on sort of the role of the caretaker for their aging parent. They'll take the parent to the grocery store, they'll help the parent with the banking, they'll help the parent with doing whatever needs to be done financially. And so then as the parent starts to get older, the parent starts to have a little more difficulty managing their own finances. So what happens, in order for a matter of convenience, many times the parent will go ahead and take this child to the bank, and they will put the child on the bank account so they can make deposits and they can write checks and they can do all those things. But the bank will go ahead and make that bank account a joint bank account in the name of the parent and in the name of the child. And so then what happens is that goes along fine, but then if the person ends up passing away, once the parent passes away, because of the way the bank account is titled, it goes to the child who was on the name of the bank account, because that was a joint bank account and it was really set up for a matter of convenience. It's not what the parent actually wanted. The parent wanted all their monies or all their stuff to be spread equally around the children. And this can cause a dispute between the remaining children, because you have the children who were not there in the everyday activities of the mom or the dad. They see either the will or the trust or both documents, and they say, hey, everything is supposed to be split. We're entitled to our pro rata percentage of the monies that were in the bank account. And then that other child, whether it's right or wrong, might be saying, well, I undertook the duty of taking care of mom, and they start rationalizing it. And I'm not here to say anything about who's right or who's wrong. All I can tell you is that this sets up a dispute so many times, and I receive so many phone calls. Well, say there's $100,000 in there and there's 2 kids or 3 kids. You know, that could be $50,000 or $33,000. Say there's a couple $100,000 in there. That could be a substantial amount of money. And I'm sure that if you were speaking with the parent wanted all their stuff to be split up equally. That's why they did it in the document. But the document in and of itself will not take the day, because a bank account is a non-probatable asset. So you have to look at the title of the bank account. If the bank account was in the mom's name and the child's name only, and they were joint tenants on that account, that money is going to go directly to the child. However, if there was a trust and the bank account was in the name of the trust, then those monies would go to the trust. But let's talk about the individual parent who puts the child's name on the bank account, so it's a joint bank account. At this point in time, the money is that child. One of the easy fixes to handle this is, during the parent's life, they can go ahead and enter a power of attorney. They can give the child who's around them the ability to do their banking and handle their finances through this power of attorney. See, a power of attorney extinguishes at the time of the person's death. So then they can title the bank account. They can either have the bank account payable to the estate, it can go into the estate. If folks are worried about probate, then you can go ahead and you can make it a pay on death or transfer on death account, and you can put it equally in the name of the children, as long as it's not 5 or 6 or 8 or 10 people that you're leaving it to. It could make it a little more difficult. But for instance, if there were 2 kids, you can put it as a pay on death account to the child who was taking care of you and to the other child who might leave out of state. This can cause and decrease a lot of problems with stress, heartache, potential litigation, and can really destroy a family, especially if the kids were not really close, the siblings were not really close as they become adults. Something like this can really tear apart the family, and there'll never be a chance of having a relationship. So the simple fix to this is a power of attorney if you're not able to handle your banking needs as you're getting older, and that way your wishes that you had in your estate planning documents will go ahead and take the day. If you have any questions about an estate planning matter, you can always give me a call. I am Guy DiMartino. Have yourself a great day.